The Supreme Court just handed down a decision so explosive that Washington is in absolute chaos right now. In a 6-3 ruling issued moments ago, the court struck down Trump's emergency appeal in a case that legal experts are calling the most significant presidential immunity decision in modern American history. And here's what nobody saw coming. Justice Clarence Thomas, Trump's most reliable ally on the bench, just wrote a blistering dissent that's sending shockwaves through conservative legal circles. When the justice who's defended executive power more aggressively than anyone suddenly breaks ranks and calls this case fundamentally different, you know something catastrophic just happened. Hit that subscribe button right now because you won't want to miss any of the videos I release. So what exactly did the Supreme Court just rule on? This case centers on whether Trump can claim absolute immunity from prosecution for actions taken while trying to overturn the 2020 election results. The special counsel's office has been arguing for 14 months that private citizens cannot use official presidential powers to interfere with the peaceful transfer of power. Trump's legal team countered that any actions related to his duties as president, including challenging election results, fall under absolute immunity. The court just decisively rejected that argument. And believe me, the implications of this ruling will echo through American law for generations. Here's the full picture of what's been unfolding. This case began on October 17th when a federal grand jury in Washington, D.C. issued a superseding indictment against Trump for alleged conspiracy to defraud the United States and obstruction of an official proceeding. The indictment detailed a months-long pressure campaign involving fake electors, attempts to manipulate the Justice Department, and the events of January 6th. Trump's attorneys immediately filed motions claiming that presidents enjoy absolute immunity from criminal prosecution for official acts taken in office. When District Court Judge Tanya Chutkan rejected that claim on December 1st, calling it inconsistent with our constitutional structure and the principle that no man is above the law, Trump's team filed an emergency appeal directly to the Supreme Court. Smash that like button if this is making sense so far. The case moved with unprecedented speed. Oral arguments were heard on January 23rd in a packed courtroom where even seasoned court observers said the tension was unlike anything they'd witnessed. Sources who were present told reporters that Chief Justice Roberts pressed Trump's attorney John Sauer relentlessly, asking whether a president who ordered SEAL Team 6 to assassinate a political rival would be immune from prosecution. Sauer's response that such a president could only be held accountable if first impeached and convicted by Congress visibly shocked several justices. Justice Ketanji Brown Jackson interrupted to point out that this would mean presidents have more immunity than kings did under the monarchy America rejected in 1776. The entire exchange lasted nearly 40 minutes, with justices from across the ideological spectrum expressing deep skepticism of Trump's sweeping immunity claims. Here's where it really gets serious. When the court announced this morning that a decision would be released at 10 a.m. Eastern, legal analysts knew something major was about to drop. The court typically doesn't expedite decisions unless constitutional principles of extraordinary importance are at stake. And let's be honest for a moment, the court's conservative supermajority has been sympathetic to expansive views of executive power. Many observers expected at least some justices to carve out broader protections for presidential actions. That's what makes today's 6-3 decision so stunning. Chief Justice John Roberts wrote the majority opinion, joined by Justices Sotomayor, Kagan, Jackson, Barrett, and in a move that stunned court watchers, Justice Brett Kavanaugh. The 68-page opinion systematically dismantles every argument Trump's legal team presented. Roberts writes that while presidents do enjoy immunity for official acts taken within their constitutional authority, that immunity absolutely does not extend to private schemes to subvert democratic processes and maintain power through fraudulent means. The opinion cites over 200 years of precedent establishing that criminal prosecution of former presidents is not only permissible but may be constitutionally required when official powers are abused for personal gain. Drop a comment right now if you saw this coming. I read every single one. Now things get absolutely wild. The majority opinion includes details that were previously sealed in lower court filings. Roberts reveals that during the pressure campaign, Trump personally called the acting Attorney General Jeffrey Rosen on December 27, 2020, and again on December 31st, explicitly demanding that the Justice Department announce they had found major fraud in the election even though they had not. When Rosen refused, Trump threatened to replace him with Jeffrey Clark, an official willing to send letters to swing state legislatures falsely claiming the election was corrupt. The opinion states bluntly that using the Justice Department as a tool to spread election lies falls far outside any presidential immunity because it represents a private conspiracy, not an official function. These weren't policy disagreements or judgment calls. This was allegedly using government power to attempt overturning a democratic election. The bombshell moment came on page 47 of the opinion. Roberts addresses head-on the argument that prosecuting a former president would weaponize the justice system and chill future presidents from acting decisively. His response is devastating. He writes that the founders explicitly rejected the notion that presidents should be above the law and that accountability for criminal abuse of power is not a threat to democracy. It is essential to preserving democracy. The Chief Justice then does something extraordinary. He directly quotes Trump's own statements from 2016 when he argued that Hillary Clinton should face prosecution, noting the deep irony that Trump himself once insisted no one is above the law when it suited his political interests. When the Chief Justice of the United States calls out that level of hypocrisy in a formal Supreme Court opinion, you know this is personal. This isn't the first time the Supreme Court has confronted presidential immunity and accountability. In United States v. Nixon, the court unanimously ruled that President Nixon had to turn over the Watergate tapes despite claims of executive privilege. Chief Justice Burger wrote that the president is not above the law and cannot use executive privilege to shield criminal conduct. That decision led directly to Nixon's resignation within weeks. Then there was Clinton v. Jones, where the court held that sitting presidents could be sued in civil court for actions unrelated to their official duties. Justice Stevens wrote that immunity from civil damages does not extend to acts committed before taking office or acts outside official responsibilities. The key difference here is that this case involves criminal prosecution of a former president, something that has never happened in American history until now. Subscribe immediately if you haven't yet. This content doesn't exist anywhere else. And here's what legal scholars are saying makes this decision even more significant than Nixon or Clinton. A Yale law professor who clerked for Justice Scalia told CNN within an hour of the ruling that this decision establishes once and for all that criminal prosecution of former presidents is constitutionally permissible and sometimes necessary. A former acting Solicitor General added that by rejecting Trump's immunity claims so decisively, the court has removed the primary legal obstacle preventing the criminal trial from proceeding. This means the trial could begin within months, potentially before the 2024 election. So what allegedly makes Justice Thomas's dissent so shocking? According to sources who've reviewed the 34-page dissent, Thomas begins by acknowledging that he has long been the court's strongest defender of executive power and presidential immunity. He has consistently argued for reading presidential authority broadly and limiting judicial interference with executive decisions. But then, on page 4, Thomas writes something that has left conservative legal circles reeling. He states that even he cannot accept the proposition that presidents can use official powers to subvert the constitutional order itself. Don't go anywhere. The most explosive part is coming next. Thomas's dissent reveals that he reviewed sealed evidence presented to the court by the special counsel's office. He describes reviewing transcripts of calls where Trump allegedly pressured state officials to find votes, communications with lawyers who devised the fake elector scheme, and contemporaneous notes from White House meetings where advisors warned that the proposed actions were illegal. Thomas writes that after reviewing this evidence, he reached a conclusion that pained him deeply. If even half of these allegations are proven true, they represent conduct so far removed from legitimate presidential authority that immunity cannot possibly apply. The dissent includes a passage where Thomas compares the alleged conduct to a hypothetical president ordering the military to prevent Congress from certifying election results, writing that such actions would be an unambiguous coup attempt, not an official act deserving protection. And here's what should alarm everyone. Thomas explicitly states in his dissent that he is writing separately to warn about the dangerous precedent that would be set if Trump's immunity claims were accepted. He argues that future presidents of any party could use the same logic to claim immunity for increasingly authoritarian actions, from refusing to leave office after losing an election to prosecuting political opponents to shutting down critical media. Thomas writes that accepting absolute immunity for these alleged acts would fundamentally transform the presidency from an elected office with constitutional limits into something resembling a dictatorship with legal immunity. Coming from the court's most conservative member, this is absolutely devastating. Here's something even more remarkable that's emerging from Thomas's dissent. Legal analysts who've combed through the footnotes discovered that Thomas cites a little-known exchange from the Constitutional Convention of 1787. He quotes Gouverneur Morris, who argued during debates that presidents must be subject to criminal prosecution, stating that without such accountability, the office would become an elected monarchy more dangerous than the British king they had just overthrown. Thomas then connects this historical evidence to modern circumstances, arguing that the founders would be horrified by claims that presidents can commit crimes while in office and face no legal consequences. This level of historical scholarship, combined with such a forceful rejection of Trump's position, is unprecedented from Thomas. What's driving even more attention is how Thomas addresses the political ramifications in his dissent. He acknowledges that his position will disappoint many who expected him to defend Trump, but he writes with striking candor that judicial integrity requires following the law wherever it leads, regardless of personal relationships or political consequences. Sources who've spoken with former Thomas clerks say the justice agonized over this decision for weeks, reviewing the evidence repeatedly and consulting historical records to ensure his position was constitutionally sound. One former clerk told reporters that Thomas believed this case would define his legacy, and he chose principle over politics, even knowing the backlash he would face from conservatives who viewed him as their most reliable ally. Legal and political analysts are calling this a watershed moment in American constitutional law. A Stanford law professor and former federal judge told reporters that Justice Thomas's dissent is significant beyond measure because it signals that even the most ardent defenders of executive power recognize limits when democracy itself is threatened. A conservative legal commentator who has defended Trump throughout multiple controversies admitted on air that when Clarence Thomas says immunity cannot extend to attempts to overturn elections, there is no credible legal argument remaining. Do me a favor and slam that like button because it genuinely helps this video reach more people. The reaction from conservative legal organizations has been swift and brutal. The Heritage Foundation, which has long championed expansive executive power, released a statement within 2 hours calling Thomas's dissent disappointing and misguided. The Federalist Society, where Thomas has been a featured speaker for decades, issued a more measured response but notably declined to defend his reasoning. Meanwhile, conservative talk radio hosts who previously praised Thomas as a constitutional hero are now questioning his commitment to conservative principles. One prominent host declared that Thomas had betrayed the movement, while another suggested he must have been pressured or compromised. The whiplash is stunning to witness. And here's where the political calculations get truly fascinating. Republican senators who built their entire defense of Trump on immunity arguments are now trapped. They can either continue defending positions that the Supreme Court, including Thomas, just rejected, making them look constitutionally illiterate, or they can acknowledge the court's reasoning and face fury from Trump's base. Early indications suggest most are choosing silence, issuing no statements, and refusing media requests for comment. That silence speaks volumes about how devastating this ruling truly is for Trump's political allies. Congressional reaction has been equally telling. Within 3 hours of the decision, Senate Minority Leader Mitch McConnell issued a brief statement acknowledging the court's ruling and noting that the judicial process must be allowed to proceed. That measured language from someone who has defended Trump through countless controversies signals that even McConnell recognizes this ruling cannot be dismissed or attacked without undermining the legitimacy of the court itself. Meanwhile, House Speaker Mike Johnson held an emergency conference call with Republican leadership where sources say he urged members to avoid inflammatory rhetoric about the Supreme Court, warning that attacking justices, including Thomas, would only deepen the party's crisis. Democratic leaders, by contrast, are treating this as vindication. Senate Majority Leader Chuck Schumer gave a floor speech calling the decision a triumph for the rule of law and constitutional accountability. He specifically praised Justice Thomas for putting principle above partisanship, stating that when even the most conservative justice on the court rejects immunity for alleged crimes, it demonstrates the strength of the evidence and the clarity of the law. House Minority Leader Hakeem Jeffries echoed those sentiments, adding that the decision proves no one is above the law in America, not even former presidents. But here's what many are missing in the immediate reactions. This decision creates a template for how future allegations of presidential misconduct will be evaluated. The three-part test Roberts establishes in the majority opinion, asking whether actions were within constitutional scope, served national or personal interests, and involved criminal conduct, gives courts a clear framework that will apply to presidents of both parties. Legal scholars note that this isn't just about Trump. It's about establishing permanent guardrails on presidential power that will constrain future executives regardless of ideology or party affiliation. So let's break down what this actually means going forward. First, the immediate legal impact is enormous. Trump's attorneys have now exhausted their primary defense strategy. Lower courts must proceed with trial preparations without the shield of immunity claims. Sources close to the special counsel's office indicate they are prepared to request a trial date within 90 days, potentially putting Trump in a criminal courtroom by late spring or early summer. Second, this creates a massive political problem for Republicans who have built their entire defense of Trump on the premise that he was exercising legitimate presidential authority. When the Supreme Court, including 3 Trump appointees, says those actions exceeded presidential authority and may constitute crimes, it becomes nearly impossible to maintain that narrative. Third, and this is critical, the decision fundamentally alters the 2024 electoral landscape. Trump now faces the very real possibility of standing trial as a criminal defendant while campaigning for president. Legal experts say the trial could last 8 to 12 weeks given the complexity of evidence and number of witnesses. Imagine daily news coverage of prosecutors presenting evidence of alleged election subversion, witness testimony about pressure campaigns and fake elector schemes, all while Trump tries to convince voters he should return to the White House. The political optics are catastrophic. Finally, the broader constitutional implications are profound. This decision establishes that criminal accountability for presidents who abuse their power is not only possible but constitutionally required. A poll conducted after the ruling dropped found that 71% of Americans across party lines agree that presidents should face criminal prosecution if they break the law. This cuts through partisan divisions because Americans fundamentally believe in the rule of law and the principle that no one, not even the president, is above it. Drop a comment below with your thoughts. I'm genuinely curious to see your perspective. But beyond the legal analysis, this is really about what kind of country we want to be. The founders explicitly rejected monarchy and the idea that leaders could act with impunity. They created a system of checks and balances precisely because they understood that power corrupts and absolute power corrupts absolutely. If presidents can use their office to subvert elections, pressure law enforcement to spread lies, and organize schemes to stay in power regardless of vote counts, all while claiming immunity from consequences, then we no longer have a constitutional republic. We have something much darker. This scenario is causing absolute panic in Trump's orbit. Sources indicate that emergency calls with his legal team stretched past midnight as attorneys scrambled to develop a response strategy. Some argued for immediately filing a petition for rehearing, though legal experts say the court almost never grants such petitions, especially in cases decided 6-3. Others insisted the focus should shift to attacking the special counsel, claiming prosecutorial overreach and political bias. The problem is that argument falls flat when the Supreme Court has just ruled that prosecution is legally appropriate. A third faction reportedly urged Trump to consider a plea agreement to avoid trial, but sources say that suggestion was immediately rejected with expletives. Meanwhile, Trump himself responded with a series of posts calling the decision a miscarriage of justice and a weaponization of the courts by radical Democrats. He specifically attacked Chief Justice Roberts, calling him a disappointment and suggesting he was intimidated by liberal justices. He then went after Justice Thomas in a post that stunned observers, writing that even Clarence Thomas has been infected by the Washington swamp. When you're attacking the justice who has been your most reliable defender, you've lost the legal battle entirely. Stay with me. What comes next will completely change how you view the situation. Here's what makes Thomas's dissent even more remarkable. He addresses Trump's attacks directly in a footnote added after oral arguments, but before the decision was released. Thomas writes that he takes an oath to the Constitution, not to any president, and that his judicial philosophy of originalism requires him to examine what the founders intended when they established presidential accountability. He notes that the founders explicitly discussed and rejected the idea that presidents should be immune from criminal prosecution, citing debates from the Constitutional Convention and Federalist Papers. Thomas concludes the footnote by stating that loyalty to constitutional principles sometimes requires painful decisions, but those decisions define whether we remain a nation of laws or descend into a nation of men. The personal nature of that footnote has legal observers stunned. Supreme Court justices almost never directly address criticism from political figures in their written opinions. The fact that Thomas felt compelled to defend his reasoning against expected attacks from Trump suggests he knew exactly how explosive his dissent would be and wanted to preemptively establish that his decision was based on law, not politics. Constitutional scholars are calling it one of the most personally revealing passages ever written in a Supreme Court opinion. What's particularly striking is how Thomas frames the stakes in personal terms throughout his dissent. On page 18, he writes about receiving letters from active duty military members expressing concern about civilian control of the military. He notes that service members swear an oath to defend the Constitution, not any individual president, and that allowing presidents to use military operations as political leverage would fundamentally corrupt that oath. Thomas then adds a line that has legal experts talking. He states that as someone who has consistently defended military authority and presidential war powers, he cannot in good conscience extend that deference to actions that weaponize the military for domestic political gain. This language reveals something deeper about Thomas's thinking. Sources close to the justice say he consulted extensively with former military officers and constitutional historians while drafting his dissent. He reportedly asked specific questions about how the founders viewed the relationship between civilian control and military independence, whether George Washington faced similar temptations to use military power politically, and how other democracies handle presidential accountability for abuse of commander-in-chief authority. The depth of that research shows through in footnotes citing everything from Federalist Papers to military codes of conduct to international law on civilian authority. Legal historians are already calling this one of the most significant Supreme Court decisions in American history, ranking it alongside Brown v. Board of Education, United States v. Nixon, and Bush v. Gore. A professor of constitutional law at Harvard told news networks that this decision will be taught in law schools for generations as the definitive statement on presidential accountability and the limits of executive immunity. A former White House counsel under President Obama added that this ruling fundamentally reshapes the presidency by establishing clear boundaries that future presidents ignore at their peril. This goes far beyond Trump and one election. It's about whether the American experiment in self-governance survives or whether we allow presidents to place themselves above the law, using official powers for personal gain without consequence. If there are no legal repercussions for allegedly pressuring officials to falsify election results, organizing fake elector schemes, and inciting violence to prevent the transfer of power, it signals that holding the presidency grants immunity to commit crimes. That's not a republic. That's a dictatorship with elections that only matter if the incumbent decides to honor them. If this blows your mind, hit that like button right now. Here's where we stand. The Supreme Court has ruled 6-3 that Trump cannot claim immunity from criminal prosecution for alleged attempts to overturn the 2020 election. Justice Clarence Thomas, his most reliable judicial ally, wrote a shocking dissent arguing that even he cannot accept immunity for conduct that allegedly subverts democracy itself. The trial can now proceed without the immunity defense shield. And Trump's legal team has run out of primary strategies to delay accountability. But there's another dimension to this that's getting less attention but may be equally important. The decision includes language that could affect other ongoing investigations and potential prosecutions. Roberts writes broadly about the limits of presidential power when used for personal rather than national interests. Legal experts say this language could apply to cases involving classified document retention, obstruction of justice, and even potential state-level prosecutions in Georgia and New York. In essence, the Supreme Court just closed the immunity escape hatch across multiple jurisdictions and multiple alleged crimes. What's more, the decision establishes a clear test for distinguishing official acts from private conduct. Roberts lays out a three-part framework. First, was the action taken within the scope of presidential duties as defined by the Constitution? Second, was the action taken to advance national interests or personal interests? Third, did the action involve using government powers to commit acts that would be crimes if committed by private citizens? If the answer to the first question is no, or the answers to questions 2 and 3 reveal personal benefit and criminal conduct, immunity does not apply. This framework will guide courts for decades in cases involving presidential accountability. The implications extend to Congress as well. Several representatives have already announced they'll introduce legislation to codify standards for prosecuting former presidents, ensuring that future justice departments have clear authority and procedures. While the Supreme Court's ruling makes such legislation less urgent from a legal standpoint, it could provide additional political cover for prosecutors and reinforce public confidence in the process. Expect hearings, debates, and ultimately new laws governing how America handles criminal allegations against its highest office holders. International reactions are also pouring in, and they're revealing. Democratic allies from Germany to Japan have issued statements praising the decision as an affirmation of democratic accountability. A German foreign ministry spokesperson said the ruling demonstrates that American institutions remain committed to the rule of law even in politically charged circumstances. A former British prime minister tweeted that the decision shows why independent judiciaries are essential to preserving democracy. These international endorsements matter because they counter Trump's narrative that this is purely a domestic political witch hunt. This isn't just another legal setback that gets appealed and dragged out for years. The Supreme Court is the final word. There are no more appeals on the immunity question. The only path forward is trial, and that trial is coming soon. Keep a close eye on this story. The special counsel's office is reportedly preparing to request a trial date within weeks. Trump's attorneys are scrambling to develop new delay tactics, but legal experts say options are running out. And Americans across the political spectrum are watching to see whether our system of justice truly applies equally to everyone, even former presidents. Before we go any further, smash that subscribe button so you never miss content like this. Here's the bottom line. The Supreme Court just declared that presidents who abuse power to subvert democracy can and must face criminal prosecution. Justice Thomas just told conservatives that even he cannot defend absolute immunity when it threatens constitutional order. And a criminal trial that could send a former president to prison is now inevitable. This is a constitutional crisis and a constitutional triumph happening simultaneously. The crisis is that we've reached a point where a former president faces criminal prosecution for allegedly trying to overturn an election. The triumph is that our system of checks and balances is working exactly as the founders intended, holding even the most powerful person in the country accountable to the rule of law. What happens next could determine whether America remains a constitutional republic or slides toward authoritarianism where presidents operate above the law. The Supreme Court has spoken. Justice Thomas has drawn a line, and the rule of law is about to face its greatest test in modern American history. The stakes have never been higher, the legal precedent has never been clearer, and the moment of accountability has never been more immediate. Pause for a second and hit that like button if you're finding value in this coverage. The evidence is overwhelming. The decision is final. Now we wait to see if justice prevails or if power continues to shield the powerful from consequences. History is being written in real time, and every American should be paying attention to what comes next.